of safety, which means that regulation should include a margin of safety limiting activities below the level at which adverse effects have not been found or predicted. So, isa non-preclusion, lack of scientific certainty should not prevent you from doing something. Yung sa margin of safety, you should only act below a certain margin to make sure that there is no harm that is being committed. It could also mean best available technology, or that the best available technology requirements should be imposed on activities that pose an uncertain potential or create substantial harm, unless those in favor of those activities can show that they present no appreciable risk. Like, for instance, there was this issue before involving oil rigs, whether what kind of devices should oil rigs apply to avoid possible oil spills. Under the standard of best available technology, as a precautionary principle, you're supposed to apply the very best kind, not just the cheapest, not just the middle of the road. Precautionary principle requires you to apply the very best technology even if it is expensive, because that's how the principle is applied. And finally, prohibitory precautionary principle, or that prohibition should be imposed on activities that have an uncertain potential to impose substantial harm, unless those in favor of those risks can show that they present no risk. And so, if you look at the different definitions, most commentators would say that these are the basic elements of the precautionary principle. There must be an appreciation of the degree and certainty of the danger that justifies a regulatory response. That there must be an understanding of the certainty of the perceived harm of taking the regulatory measure. Third, there must be some regulatory response. And finally, it is understood that this regulatory response is provisional in nature and may be subject to better certainty in the future. Meaning, once the danger has passed, for instance, certain animals, I think it's the panda, if I'm not mistaken, who was recently taken out of the endangered species list. So whatever measures that they put in there because of precautionary principle can now be removed because it has repopulated to the extent that it's no longer an endangered species. So the danger is gone. Rationale and the effects, well, the precautionary principle is a policy framework that addresses risks in cases involving uncertainty and ignorance, as in the case of climate change. It was originally formulated as a response to the constraints of policy and science insufficiently addressing complex and uncertain risks and its consequences to human health and the environment. The Rio Declaration and the Wingspread Declaration, although these statements differ, they share a common core. All of these different statements have something in common. And that is that we should seek to prevent some threats of damage, particularly threats of serious or environmental damage, even if we lack scientific certainty about their existence or magnitude. And some have said that the principle, precautionary principle, is understood as an alternative to the cost-benefit analysis. A major function of the precautionary principle is also the redistribution of the burden of scientific uncertainty. Whereas actors in the past could act as if they were ecologically independent by ignoring weak signals of transboundary damage, such behavior is no longer acceptable. By lowering the threshold of scientific evidence of threats of serious or irreversible damage to human health or the environment, it required to trigger deliberations. The precautionary principle is speeding up the process by which underlying ecological interdependence is recognized and translated into policy. Meaning, you can no longer ignore even small signals or weak signals of possible environmental damage. You're supposed to consider in your policy planning. And the precautionary principle places on those wishing to undertake an action the burden that it will not harm the environment. In its absolute form, the essence of the precautionary approach is not a rejection of scientific and economic analysis, but merely the reversal of a burden of proof. While the principle stems from the inadequacy of scientific knowledge, its qualified application sensibly requires the use of the best available science and economics to establish the appropriate standards of proof that would-be developers must meet. In this sense, the rule on precautionary principle is merely a rule on evidence. So I guess this cartoon illustrates the difference or the effect of the precautionary principle. Either we will get out when you prove that we will be boiled alive, or we should get out until you prove that we won't be burned alive. So I guess we see the wisdom of the precautionary principle there. Well, at least if you're a fraud. Alright. The precautionary principle encourages policies that protect human health and environment in the face of uncertain risks. It's not a new concept, it's just been more recently advocated in instruments maybe because of the dangers that we face today. The beauty or the advantage of the precautionary principles is that it forces or gives us the ability to act quick on threats to the environment. We don't have to wait. As long as you are able to show scientifically, data, that there are serious or irreversible threats, then you have the reason to act despite the absence of certainty. Precaution embodied ideals of damage to the natural world should be avoided in advance. Thus, the precautionary principle is based on the premise that when it comes to dangers to the environment, preventive action should not wait. So it is implicitly based on the acceptance that collective human knowledge may not have been able to fully comprehend with certainty the consequence of human activity. Because I guess it's precautionary principles the acceptance of that principle is an admission of our, it's a humble admission that we don't know everything. And just because we don't know everything yet doesn't mean that we shouldn't be acting now if there is a danger that we are facing. Now, the status of the principle under international law is what's in the next section. Just to I know there are a few lawyers in the room, but some may not, so let me just explain that under international law, there are four sources of law, four sources of international law. Under Article 38 of the Statute of the International Court of Justice. The most common source of international law today would be international conventions. These are treaties. These are things which presidents wish or won't wish to sign. Okay, these are the usual way we set international law. And there's what you call international custom. It's similar to what we have under, in our society. There are things that we do. It's not written down. There's no rule that says we should do it that way. But because we've always done it that way, it's become customary. Under international law, it's a little bit more complicated than that. But custom can also be a source of law under international law. The third is what we call general principles of civilized nations. Now, that's a rather antiquated term. It was written in the 1900s. But the idea is that all countries of the world, all governments, all legal systems have certain basic principles that are common to all. And although these are domestic law in nature, they can be applied in international law. And finally, you have what international calls subsidiary sources. And these are the decisions of judges and teachings of the most highly qualified publicists. There is no definition for that one. But they're basically people who are respected. Their writings are considered as a form of international law. Now, treaties, international conventions, is the precautionary principle part of that? Yes. Since 1984, I'm not sure if I've been able to update this data to 2016. But as of the time of the paper being cited here, the precautionary principle has been incorporated in 29 international environmental agreements and 7 international declarations. It's widely used. And in fact, it's difficult to find an international environmental agreement that does not mention the precautionary principle. And the basic formulation of the precautionary principle in all of these treaties, in all of these conventions, is that under current international agreements, it states that if there is a risk or a threat of serious and unacceptable damage to human health or the environment, Reasonable precautionary action should be taken despite lack of absolute certainty with regards to its causes and impact. That's the common element in the way the precautionary principle is written in the treaties. What about custom? Well, under international law, for something to be considered as customary, it must satisfy two elements: state practice and opinio juris. State practice means that it is the way governments and states have been acting. They follow a particular way of doing things. It is usually found in their official pronouncements, their declarations, their actual actions in international relations. Opinio juris is a subjective element. It requires that the state or the government doing this state practice did it out of a belief that it is law. So parang when they did perform this state practice, they did so not because they were forced to or they, it's just out of comity, but because they believe that they should. This is actually a very controversial concept of state practice and of customary law. We can spend weeks just talking about it, but let's just leave it at that for a moment. And it has been said that the precautionary principle already satisfies state practice and opinio juris. There are many authors that say that there is sufficient state practice and opinio juris. Looking at all the treaties as state practice, all the declarations, and the mention of the precautionary principle and General Assembly resolutions reflecting opinio juris, so it's customary. So even outside of the treaties, because the difference between custom and treaty is this: you're only bound by a treaty if you're a party to it. In custom, everyone is bound by it, regardless of whether or not the custom arose before you became a country or not. Everyone is bound by customary law. Now, some people or some authors still reject the precautionary principle as customary, but at the very least, it could be the third kind of source of international law, which is a general principle of law. Remember, a general principle of law is a legal principle found in common in many different legal systems. So we see that it's in Germany, and we will see later on that the precautionary principle is also in our Philippine legal system. And if we search, we will probably find the same principle in the domestic laws of many countries. So therefore, at the very least, the precautionary principle is a general principle of law. So that's its status under international law. What about Philippine law? First, let's look at statutes issued by Congress and administrative issuances. In the Climate Change Act, it's mentioned in the Declaration of Policy. If I just read the last paragraph, it says, "Toward this end, the state adopts the principle of protecting the climate system for the benefit of humankind on the basis of climate justice for common but differentiated responsibilities and the precautionary principle to guide decision-making in climate risk management." So it serves as a guide. Also, you find this again in the Declaration of Policy for the Tubataha Reefs National Park Act. You have it also in the law amending the Fisheries Code, again as a guiding principle to fisheries management. You find it in ordinances. There are too many to mention, so let me just say that there are several ordinances. Why do I put it here? Because ordinances issued by local government units are issued in the power of the local governments to issue laws and regulations within their areas. So in a sense, they're legislation issued by the Sanggunians. And there are many ordinances. For lack of time, I can't go through each of them right now. And these are some ways it has been applied. There are also many administrative issuances. And the value of administrative issuances is that these usually fill in the details that the acts of Congress do not provide for. So there are also many administrative issuances that make use of the precautionary principle. So I'm going now to jurisprudence. I'd like to spend a little bit more time here because I know we all like stories. First, we have the case of SJS officers versus Lim. This case involves the ordinance in Manila, ordinance number 8187, which it created a medium industrial zone and a heavy industrial zone. So this is the conductant thing, the conductant case. So let me just, yes, the oil depot. And the court, that we get to the ending, declared the ordinance unconstitutional, this particular ordinance. And the court, the creation of a medium industrial zone and heavy industrial zone effectively lifted the prohibition against the owners and operators of businesses and so on. And then the court declared it unconstitutional, not applying the precautionary principle. It's here not because of that. It's here because Justice Leonen, in his dissenting opinion, made reference to the precautionary principle. He said that the precautionary principle certainly does not sanction a suspension of judicial rules with respect to evidence, reason, and legal interpretation. So, while the precautionary principle is a good principle, it does not trump other legal rules. It has to play within the system. He also said that the precautionary principle applies when it can be shown that there is plausible risk and its causes cannot be determined with scientific certainty. It is not available simply on the basis of imagined fears or imagined causes. Otherwise, it will be absurd. Rather than a reactive approach to fear, the precautionary principle is an evolving proactive action in protecting the environment. Furthermore, being only a principle, it does not trump the requirements for proper invocation of remedies or act to repeal existing laws. Next case is the West Tower versus First Philippines. This is the case where you had oil leaking into the condominium. I don't know if you remember that. This case involved a petition for the issuance of a writ of kalikasan filed following the leak in the oil pipeline owned by First Philippine Industrial Corporation in Makati City. The court ordered First Philippines to address the problem and submit to monitoring. Now, as for the application of the principle, there was, you see, a part of the majority opinion where Justice Velasco, the ponente, meaning the writer of the decision, was addressing the dissenting opinion. There was a dissenting opinion again, written by Justice Leonen. And the majority had an opportunity. It's kind of weird, right? But that's how our cases are written. There's a majority opinion and there's a dissenting opinion. But because you're the majority opinion, you can read the dissenting opinion and then address it also in the majority opinion. Pero pag ikaw yung writer ng dissent, wala kang opportunity to address. So anyway, Justice Velasco, in the majority opinion, was pointing out that they were not applying the precautionary principle in this particular case. The reason why they were not applying the principle is because the principle is only invoked when there is a lack of certainty. In this case, Justice Velasco was saying it was certain. It was sure. The leak came from the pipes. So there's no reason. And the basis, so basically Justice Velasco was saying, Justice Leonen is wrong. He thinks we're basing our decision on the precautionary principle. Whereas in fact, we're not. We're basing it on other things. Because the precautionary principle cannot apply when you know the cause of the environmental damage. That's according to Velasco. And this is what he says, okay? Leonen, in his dissenting opinion, which is the one the majority was responding to, he said this: strict application of the precautionary principle means that the mere presence of uncertainty renders the degree of scientific plausibility for environmental damage irrelevant. Speculations may be sufficient for causes for the grant of either a temporary environmental protection order or a permanent environmental protection order, regardless of the extent of the losses resulting from it. This interpretation may be consistent with the purposes of avoiding the threat or damage to the environment and to the people's general welfare. Do you understand that? Justice Leonen was also my professor, and he would always say things we would never understand. He has a tendency to speak that way. Pero there's a paragraph, it's not included in your slides, to help us understand what that statement means. There's this paragraph in his dissenting opinion, where he says this: dealing with environmental issues is not as simple as applying the precautionary principle in strict sense when faced with uncertainty. We must recognize that interconnectedness of